Schedule CP is called career policy, and it's creating a new category of federal employees. Up until now, we've had political appointees and career employees. And this one is saying, well, there's a branch of career employees that don't deserve the rights of the merit system and the competitive service. They're really policy people. They're part of the president's team, and he should have at-will authority over them, or much greater authority over them. President Trump issued an executive order at the end of his first term called Schedule F Executive Order, creating this new class of workers. The significance of being in that class is that you would no longer have access to the independent agencies that enforce the merit system, the Merit Systems Protection Board or the Office of Special Counsel. As the executive order stated, you'd still have all your same rights, but now they would be enforced by the agency where you work. In other words, the institution that's since 1979 been the defendant in employee rights challenges will now be the judge and jury of its own institutional actions. In other words, turning the Merit System and Whistleblower Protection Act in the process pretty much into a bad joke. Well, the administration said this is only for about 50,000 workers. So, you know, we're establishing more realistic boundaries for political. Who has enforcement responsibilities, who has any discretionary authority, who works for somebody who's GS-13 or greater. In other words, pretty much everybody except maybe food service workers, maintenance workers, pretty much the entire civil service system that provides functions for the citizens will be now career policy. At the Office of Personnel Management, just for their own staff, they say, well, this will be about between 80 and 85% of our workers will now lose their merit system independent enforcement rights. So that's one front that needs to be challenged. The other front is basically putting political puppets into the agencies that enforce the merit system to the extent that they do survive. And so, although Congress in statutes passed unanimously and signed by prior presidents gave some job security to the people in these independent watchdog agencies, President Trump has said that this is unconstitutional because as the president, he has absolute authority to manage the executive branch without interference from Congress. And we've seen this throughout the government. The president fired Hampton Dellinger, the special counsel, who is kind of the hub of whistleblower protection, investigative and remedial actions, and had been doing an outstanding job. I thought he was the best special counsel in the history of the office. And they succeeded in that. And we'll go into the counterattacks in a few minutes. They also, the administration and the White House fired the members of the Merit Systems Protection Board, which has the due process responsibilities. If you don't get help from the Office of Special Counsel at kind of the informal investigative level, you have the right to a day in court at the administrative level before the Merit Systems Protection Board. And they have a bipartisan board that oversees the administrative judges at that agency. And all the Democrats who are on the board have been fired or left early, which would mean that the board wouldn't be really a very viable, legitimate place to have your day in court. During President Trump's first administration, we we led a campaign to successfully stop his appointment of a nominee for the Merit Systems Protection Board who wanted to reinstitute the Malek Manual. For those of you who are my age, you might remember the Malek Manual from the Watergate scandal, because it was a secret attempt by President Nixon to purge anybody from the executive branch who wouldn't be a political loyalist and basically restore the spoils system. And that's what Schedule CP is attempting to do openly. And the last nominee for Merit Systems Protection Board chair wanted to implement the Malek Manual through the adjudicative agency to guard against merit system threats. So if the president succeeds in removing the current members of the board, we think that it'll probably be a rubber stamp for retaliation. And that's also the case at the Office of Special Counsel, where the president has appointed a gentleman named Doug Collins to be the acting special counsel. Mr. Collins is the secretary of the Department of Veterans Affairs, and special counsel isn't a part-time moonlighting job. But even more than the lack of capacity to defend the merit system effectively, the Department of Veterans Affairs is responsible for about 40% of the whistleblower retaliation complaints annually that the Office of Special Counsel receives. So the head of the worst agency in the government for whistleblower retaliation will now be in charge of protecting whistleblowers from his own managers as well as those throughout the rest of the executive branch. So there's kind of basically a double-barreled attack on the merit system to move people out of it, but for those who are still in, to deprive them of any sort of an independent or objective forum to defend their rights. That's the threats that we're facing currently. What are the counterattacks to these threats? Well, with respect to the Office of Special Counsel, Mr. Dellinger, he challenged this as being illegal, since Congress had said he can only be removed for cause. He said it was illegal, it's unconstitutional, and he obtained a temporary restraining order, which was upheld by the Court of Appeals and the Supreme Court. When it went back for a preliminary injunction, the district court judge extended the temporary restraining order, which is just freezes things for a matter of days, to a preliminary injunction, which would halt any government actions until the conclusion of the case. The Trump administration immediately appealed that. The Court of Appeals signaled that they were going to rule in favor of the administration against the special counsel, and he withdrew the case then to avoid a bad legal precedent being put on the books. So that one, we pretty much played out the string. And, if you're blowing the whistle on the Biden administration, the Office of Special Counsel may still be a viable resource for support. If you're blowing the whistle on the Trump administration, it'll be an act of professional suicide to bring issues to the Office of Special Counsel. The second counterattack is against the attempt to fire Kathy Harris, the chair of the Merit Systems Protection Board, as well as the members of the National Labor Relations Board, and there was an attempt to fire the head of the Federal Labor Relations Authority. So far, which, as Larry pointed out, is the institution that shepherds collective bargaining agreement, labor management arbitrations. And it's very, very significant because collective bargaining arbitrations through the union they're determined by independent arbitrators. And so it's not a kangaroo court. It's not something which you be a miracle if they didn't rubber stamp whatever the employee was challenging. It may be our last holdout for um, uh, fair enforcement of the Whistleblower Protection Act. And the head of the Federal Labor Relations Authority, Susan Grundmann, who'd formerly been the chair of the MSPB, prevailed in getting a temporary restraining order, and the administration didn't challenge it because her term is about to end. But I talked with Ms. Grundmann this morning, and she said that the very heavily favored conventional wisdom is that she'll be replaced by a gentleman named Noah Peters. Mr. Peters has been the author for all of the Office of Personnel Management's purge initiatives, whether it ranges from Schedule CP to take people out of the civil service system, or the mass layoffs and rifts that have been occurring at different agencies without respect to civil service rights. He's been the author of all those, and we anticipate that he'll be nominated to be the next chair of the Federal Labor Relations Authority, enforcing your rights under collective bargaining agreements. GAP will be actively involved in challenging that nomination. There's already a team that's been assembled to do that. But that's one counterattack. The litigation one was successful. The political one is disaster in the wings, and we'll be waging a political fight in Congress to challenge his confirmation. With respect to the other counterattacks that have taken place, GAP is representing employees at the Voice of America, kind of like class action lawsuit, and we're finalizing representation of the January 6th prosecutors who are being fired for their work in those prosecutions. They're pretty high-profile cases. There'll be a program on 60 Minutes this Sunday about the Voice of America lawsuit. It was in the Washington Post and the New York Times yesterday or the day before. We filed it on Friday. But there's going to be a whole host of counterattacks on behalf of individual workers at various government agencies. And I'm kind of inspired that the legal community and Larry was saying, usually to get a lawyer you have to kind of mortgage your life, and if you run out of funds, you run out of rights, and GAP's an exception to that. We're not a commercial operation, but all these law firms that wouldn't return my phone calls when I was seeking pro bono assistance are raising their hands now and volunteering and saying, we want to help. And I think the legal profession has a self-interest in doing pro bono work at this stage, because these are all lawyers whose bread and butter is civil service cases, and there won't be any more civil service cases if the administration gets its way. So it's kind of an investment for them. We're at the hub of a large network of volunteer lawyers to help with intakes, to help with legal research, and a number of them have said they're on call for representation. There's a fairly impressive team within DC that's been kind of following the same lead. A law firm headed by Gary Gilbert. Gary Gilbert and friends is teaming up with us on a lot of these cases and is very, very skilled in civil service law. Gary was a former regional chief administrative law judge for the EEOC before he went into employment law. Norm Eisen, who is the former ethics counselor for the White House during President Obama's term, is in a law firm handling a lot of these cases. A law firm headed by a lady named Kristen Alden, A-L-D-E-N, is an excellent resource, and her top lawyer is Jim Eisenman, who was the executive director of the Merit Systems Protection Board um, before his term ended. So there's really an unusual, kind of unique potential to get legal assistance that won't mean having to turn over all your life's assets, like is normally the case. That leads then to kind of a description of some of the rights that are at stake here and that are available for your counterattack. The first is constitutional claims. There's due process claims and First Amendment claims that are at stake here. Due process is basically purging people without respecting the various procedures, like firing people for saying that they're incompetent without going through the process of a performance improvement plan first. There's all sorts of notice requirements, opportunities to tell your side of the story. All of these are being scrapped. And due process claims are the primary, the hub of our defense of the Voice of America employees, for example. There's also First Amendment claims for violating your constitutional rights. And in the District of Columbia, which is where the hub of all these decisions are made, the DC Circuit allows you to go for equitable relief if your First Amendment rights are violated. What does equitable relief mean? Keeping your job. There's matters of law, that's damages. Equitable relief is defending your position, your employment. And in the District of Columbia, you can go to court and seek an injunction blocking the government from canceling your job due to First Amendment retaliation. You do have to exhaust your administrative remedies, however. So if it's a termination, you would have to appeal to the Merit Systems Protection Board, and you couldn't go to court until they fired you, until the board turned your case down. If it's, say, a reassignment or transfer or demotion or removal of your duties or one of the other prohibited personnel practices, you'd have to go to the Office of Special Counsel. And then you would be free if they didn't help you. My experience has been that, this might change under a hostile administration because they want people to be stuck at these administrative remedies. But historically, none of these agencies, whether it's a special counsel attorney or an administrative judge, have had any hesitation about dismissing a case. If we say we don't, we won't contest it if you want to close the case out. They're grateful because it reduces their workload. But that is a prerequisite before you can pursue constitutional claims. The second thing that's very relevant for our beat is the Whistleblower Protection Act. And I want to make a little bit of a aside here, street law course for the Whistleblower Protection Act, and then wrap this up pretty quickly so we have 10 minutes for any questions that folks might have. But under the Whistleblower Protection Act, it's illegal to take a personal action against you. If you communicate information, disclose, but it means communicate, that you reasonably believe, which means your peers could agree with you if they had the same information, is evidence, not necessarily proof, but evidence of illegality, gross waste, gross mismanagement, abuse of authority, or substantial and specific danger to public health or safety. That's the protected activity of the Whistleblower Protection Act. And it extends to people who are communicating that information just as part of their jobs, as a job duty. It doesn't have to be that you're pointing the finger, that you're making an allegation. It can be you're just preparing a report which honestly states the facts of a violation of law or a threat to public health or safety. And that's protected activity. And with a lot of the current personnel actions, there's mass purges because people communicated information that's currently politically unpopular as part of their job duties. So if you've found a significant work product that has a significant impact on public health or safety, or involves possible violations of the law, you've engaged in protected activity, and you have something which is a little bit unique compared to other people who are just being fired because they work at the agency. And it gives you a chance to defend yourself. That kind of, leads to a personal choice for people. In addition to just doing your job duties, you can blow the whistle. And if you blow the whistle openly about what's happening currently, that's protected activity. The enforcement for it is very sketchy, as I've pointed out, but you will have protected activity on your side. Really, the question is, do you want to expose yourself as standing out from the crowd as a threat to current policies? And very personal decision on a case-by-case basis. If you think that you're already targeted, or the conventionalism is very solid, that there's going to be mass purges at the Nuclear Regulatory Commission, then you really don't have much to lose. You might as well secure legal rights on a little bit higher ground. If you think that nothing dramatic is going to happen in the short term, I would be very, very discreet about engaging in any protected activity, because you'll make yourself a target then, if you're not already. So the bottom line is whether to act on your rights or just kind of keep your head down, very, very personal decision that you should be making with your family. That's sort of the things that I wanted to share as an overview this afternoon. And we've got about 10 minutes left before I have to leave for court hearing. So if anybody has any questions, I'm all ears, and I hope I've got answers for you.
Yeah, I don't see any questions in the chat, but I guess one question I might have, could you, the NRC has been described as an independent, agency created by Congress. Can you go into detail a little bit on what that entails, like in terms of the commission and what obligation we have to follow like executive orders on employee issues?
Well, let's start at the end. You're bound by the executive orders that have been successfully challenged. So you're subject to the authority of the executive branch. But we all are. So that's not such a big deal. As far as the status of independent agencies, the conventional wisdom is that their reality reflects their label, that they're independent. These are the agencies where Congress, unlike the Department of Health and Human Services or the Department of Agriculture, where the president can remove somebody at whim. These are agencies where Congress has said the agency is responsible to the legislature as well as the executive, and the president can only fire these people for cause. which then could be considered by the courts whether the president had good cause or not. The Trump administration is not respecting that boundary. They're saying that the independent agencies are unconstitutional, that the president has absolute power over the Constitution to manage the entire executive branch. And that extends to these agencies which are performing functions of the executive branch. And Congress never had any power to curb his authority over them. And that's kind of the essence of the lawsuits that are happening right now. And with respect to the Office of Special Counsel, which was, a single appointment, but following that structure, the Court of Appeals said that the president has that authority. With respect to the National Labor Relations Board, the Merit Systems Protection Board, the Federal Labor Relations Authority, we're still winning. But the jury is out, Larry.
For this Office of Special Counsel, is the special counsel appealing that ruling, or?
No, he withdrew the lawsuit when the Court of Appeals said that they were going to rule against him. And, I've talked to him since, and he wanted to prevent a landmark precedent being on the law books. So he preferred, if he was going to lose, he preferred to lose without a comment from the court. But we've lost that one. In fact, my upcoming strategy is going to be warning people against filing cases at the Office of Special Counsel, where it had been the opposite.
Thanks, Tom. This is Jeff Mittman. I'm a retired NRC employee. So I think Trump recently fired 2 Democratic commissioners. Maybe it was from the Federal Trade Commission, but one of the independent commissions. And I was wondering if the NRC is any different, whether its structure under the Atomic Energy Act is any different.
No, the rights of the NRC commissioners will be determined, in my opinion, by what happens with these cases involving the Merit Systems Protection Board, the National Labor Relations Board, and other pending litigation. The NRC will be swept up along with those outcomes.
So, as you know, right now there are 3 Democratic NRC commissioners and 2 Republicans, and the first Democratic seat doesn't expire for a couple of years yet. So, absent any retirements or action by the administration, we have a Democratic majority for a couple of years, unless the administration chooses to try and fire one of them. Any thoughts about that?
Well, there's not any uncertainty in my mind that they'll be fired. And whether or not they can defend themselves is going to depend on some of these lawsuits that are, on the front lines currently. But there's no boundaries in the administration's attack on the civil service system. This is an all-out attack to have, the theory is called the unitary president. That means the president is king of the executive branch. And they're thoroughly committed to achieving that outcome. So I don't expect there to be any pulling punches or restraint or anything like that.
All right. There's a question in the chat. It says, Tom mentioned a number of 50,000 people being made Schedule CP, but then seemed to imply that most federal employees would be made Schedule CP if the administration gets its way. Would Tom expect most NRC employees to be made Schedule CP? And, when do you think they would try to do that?
Absolutely. I have law enforcement authority. Most of you are, high enough GS levels that you're either working for a 13 or you are one. You have just authority, discretion to interpret legal requirements. All of those people are going to be covered by Schedule CP. The only people left at the NRC that I would think would still have civil service rights would be like the folks working at the food vendors table, or the security people at the front desk, or the maintenance workers.
All right. We got another question. So we have agencies established by Congress, and they have their mission, and they've been doing it successfully. How can the president just abolish agencies? And he's not really abolishing them, though, right? He's like the Department of Education. He's just put someone in charge who's firing everybody.
Well, the legal authority, again, is the unitary president. It's kind of a sweeping excuse from my perspective to do anything. If you translate that, it says, I can do whatever I want to. And what's happening currently is President Trump's testing the limits of that theory. So he's like, it flunks the left test to say that he has the legal authority to abolish the Department of Education, or remember the other initiatives that he's pursuing. But that's under conventional assumptions. If the courts adopt the unitary president theory, then he has the legal authority to do anything he wants involving the executive branch. And Congress, other than appropriations, doesn't have any controls or way to trim his discretion. Sorry to say that. And I need to split, folks, because it's one thing to be tardy, Tom, with people that I'm volunteering my help for. It's another thing to be tardy, Tom, with a judge. And so I don't want to take a risk on that one. But thank you for inviting me. And what I can close with is, GAP's defending people, a lot of people, folks at the Department of Justice, Voice of America, and we're open to defending folks at the NRC. Defending NRC and nuclear whistleblowers was how I got my start in this work over 4 decades ago. It's the issue that matters the most to me personally. And so if people who work at this agency want to get some reinforcement or assistance, you got a standing invitation to get in touch with us. And if we can't, if we're overextended and we can't do justice to your rights directly, we're the hub of a very extensive network of lawyers that we'd be referring you to, so that you won't be stuck. So I hope you don't need it, but I'm not optimistic. See everybody later.
All right, thanks a lot, Tom.
Sure.
Yeah, so this meeting was scheduled till 2:30, but yeah, as Tom said, he has after he agreed to come out, he got a legal commitment that he has to give a brief at 2:00. So we're going to have to wrap up. But I'll be sending the recording out for anyone who missed the meeting or is interested in seeing it. Thanks.
Wish I didn't have to give such a happy talk.
Yeah.
Larry, are you taking Tom out?
Yeah, I'll walk him out. I'm gonna leave my computer and stuff here.
Okay.
Thanks a lot, Kevin.
See you later.
It was nice meeting you.
Is there pizza left?
What's that?
Is there any pizza left?
I don't think so. I'm going to look through the containers, fold the boxes up and put it on the trash.
Yeah, if you find one, I'll take it down to the hot center.
Okay.